frivolous, ridiculous discrimination suit based on race. Get me out of it. What are you going to tell me? So she proceeded to say, well, I'd say, okay, let me explain to you what the different kinds of discrimination are. You know, there's direct, there's comparative, there's yada, yada. She went through the whole 9 yards. Beautiful, beautiful job. She did the nicest job of laying out employment law discrimination based on race I've ever seen. And then she did the same thing. You're going to have this problem. What about this? We got to show this. We're going to have to be able to show this. This is where you pretty much are going to be okay. Now, the benefit of that was the same for the other side. Beat them up to it. So what I did was I used the attorneys through the role play essentially to beat up the other side's party. Now, you all got these puzzled looks on your face, probably because of that phrase, beat them up. Does that bother people?
No, I'm just surprised that the attorneys would do it.
Yeah, that's what I'm.
Yeah.
Okay, well, there's actually, I think, one of the $64,000 questions. The question is what? Do they know what I'm doing or not? And that they willingly go along with it because they know the effect it's going to have. Why would they do something like that?
Intimidate
It's a way of, it seems a way of pointing out the weaknesses of the other person's case in an indirect way, in a way that, because it's not direct, is less likely to cause defensiveness and closing off, and maybe more likely to hear it.
Okay, so more likely to hear it. What else? How many practicing attorneys we got here? Anybody in here practice employment law? You do? You do? Why would an attorney let that happen? What would be the benefit to them for it to happen?
Well, employment cases can be very difficult, and they're also very emotional, and sometimes a client really can't hear what advice they're being given by their own attorney.
So it's a situation, one possibility is the attorneys have tried working with their own client and it's been an uphill climb. I mean, you got a client in a lawsuit. So what do you want to do? You don't want to go in there and knock them so far in the dirt that they don't have the wherewithal to proceed with the suit or to pursue the suit. But on the other hand, you don't want to build it up to them like it's a cakewalk, piece of cake. You're going to be out of here in a year with $1 million because you know it ain't so. They got a long way to go.
But I also, I mean, whatever a picture paints 1,000 words. I mean, there are clients sitting there seeing it, and maybe they.
Some of which they cognitively process, some of it just goes in there somewhere. You don't know what happens. But I think they probably did it. I believe those attorneys weren't stupid. I think they did it, and I think they did it willingly because they knew that it was going to allow the other side's client to see things they needed to see, and probably their attorney tried to make them see, but it was hard. But they took it hook, line, and sinker. Why? Yeah, it was done by both sides, and it was coming from over there, and it was coming to me, supposedly as them. I mean, it was convoluted enough that they were able to accept it, and indirect enough. It's in many ways, a form of a flip side, just an elaborate form of a flip side.
You know, Andy,
Tony.
I was involved in a case where I was representing management per se, and the other party had a lawyer with them, and what was real good about it is the lawyer was the logical person, and you know, the lawyer had never really heard my side of the story, and so it almost, the lawyer kind of got deflated right before my eyes when I was able to talk about what was going on. So it was a real, I mean, the lawyer was basically my best agent. You know, if the lawyer wasn't there because it was such an emotional thing for the other party,
Right.
We wouldn't have got anywhere.
See, I agree. I use attorneys that way I find attorneys are my best asset as a mediator. Deborah?
I would have to say that as a lawyer, one of the most frustrating things in litigation many times is that you wish you could just speak directly to the other side, because there can be so much filtering that goes on through the legal process, and if the parties can talk to each other, whether through the lawyers and with the help of the mediator, and it's just so true that when the lawyer actually hears from the party, as you were saying, Tony, and sometimes what the lawyer is hearing is really hearing for the first time because they're not ever able to really talk to each other directly.
And I'll bet you've had instances where you had to bite your tongue and would like to jump in there and help the other side's
Yeah.
client because their attorney's not doing a very good job.
Very, very often.
You
And
know,
it's one
even
thing-
though they're your adversary, you just like to say, listen, here, slip them a little note and
Right.
say, here, this is what you need to know,
Yeah,
kind of
yeah.
thing. I mean, I think that happens a lot. And I think that's why reversing those roles like that gives them a piece of perspective that can help them.
And I don't think that the mediator should ever assume that the lawyers are not savvy to the process and really working with the mediator to help the clients.
They are. And I can tell you, I remember once I did a case where it was a fairly high profile case in the public universities here, and it's a sexual harassment case, and we did settle it, but when we were leaving, the complainant's attorney said to me on the way out, he said, he said, you really told us what to do. And of course I was like, almost fell over backward. I'm like, I what? Tell you what to do? What do you mean I told you what to do? I don't tell people what to do. And he said, well, you really prepared us for a low offer. And his client's standing there listening to all this. You really prepared us for a low offer. And so I'm thinking to myself, well, had you heard anything other than a low offer? All I'd heard the whole 4.5 hours was a low offer, so how was it that I prepared you for anything other than a low offer? Because that's all there ever was out there. Did anybody know what he was doing?
He was using you really as
Yeah.
to tell the client what was going to happen.
Well, he's transferring the blame onto me.
Yeah.
I, the mediator, become the lightning rod. The reason his client didn't get what she wanted and deserved was because I'm a crappy mediator. You know, I couldn't get anything from the other side that lowball offer is essentially where he's going with that, which is fine. Part of what I get paid to do. The other piece to that is that people want the mediator. A lot of times, particularly attorneys, will want the mediator to beat their own client up. That's exactly what they want you to do. Now you have to be careful how you beat people up. Because remember, under this process, the way you beat people up is you're very hard on the issues and very soft on the people. You don't want somebody walking out of your mediation who's so emotionally hammered by you that, now they're just this big pile of jello and can barely function. You want to be hard on the issues, soft on the people. And that's just one way of doing it, using those little role plays and using your attorneys to talk to the other side about what the law is and how they need to set it up and what they have to prove and all those good things. Let's take a break for about 10 minutes, come back, and then we'll spend however much time you want to wrap up. I've got a couple more good ones on here that I want to show you. I guess you can turn this off now. You look public knowledge that what you've said has an effect most of the time. They're certainly not going to jump up and say, oh, you're right, I'm so sorry, let me write that check. Matter of fact, let me make it double. Pray your trouble. They're not going to do that. And the other thing that they're not going to do is a lot of times they're just not going to know the answer. That's okay, because knowing that there's information that you're missing has a value in and of itself. For a person to realize, there's parts of this I don't know about, I don't know the answer to, could be valuable for them. That could be something they need to consider. If they really don't know how a trial works, they need to think about it. They want to get up there and try to put one on. I mean, I think that's just that common sense would tell you that, and it's a good thing.
Yes, I use that with our own Meadows. You want to find out when you go. Is that when you want to find out? When you
Yeah. Yeah. I think that's a good idea. I've done that too. I've said things like, so why do you think they have lawyers? There's a reason for that, Why do you think that is? So you also want to look at the effect on relationships, whether it's a business relationship or a personal relationship. And I've done a whole lot of cases where people were interested in a business relationship. That was not obvious on the face of it, but you start talking to the business person at the table and you very quickly realize that, yeah, that matters to them. If they can preserve that business relationship, they'd like to. So those can be important things. Whether or not people want to preserve a relationship of any kind is an important thing. Because if their value and their emphasis is really on the relationship, then you need to be asking questions of like, well, how is it going to affect the relationship if you end up pursuing this court case? Or if you end up having to collect this judgment, what's that against your brother-in-law here, what's that going to be like? Right? Now, we talked about proving their case. Along with proving their case is pursuing their case. Once I've asked people, how much is it going to cost you to push this case? And we've detailed the cost of that step by step. And very typically when I do employment cases, I sort of by default do a lot of employment work here. Usually I'm talking about, at that point in a mediation, I'm talking about how much is it going to cost you to get this thing to the summary judgment phase? What kind of money would you be looking at just to get it that far? I'm going to ask, both sides. You've got the staying power to do that. Particularly your complainant. Particularly if it's a pro se complainant. You have the staying power to stay in litigation for that long. Can you pay the costs? Can you pay the fees? What happens to you if you run out of money? Where does your complaints go? Because a lot of people have complaints. They want to pursue them. They have the chutzpah to pursue them, but they don't have the money. Just plain and simple, they don't have it. And they need to think in terms of the reality of that. So not just proving the case, pursuing the case. Use of objective criteria. Now, what are some forms of objective criteria that people can think about? What's the classic form of objective criteria? A case, very similar to yours, that's been decided by the court. But there's a verdict on it, and there's an award, and you can look at it and you can say, hey, here's my case, and here's what they got. Right? Now, there are problems with that, right? If you're looking at a case that's in Cook County, and you're about to try one in Lake County, that might not really connect up. There could be a problem even with that kind of thing, where it is. I did one this week in which the complainant's attorney said to the respondent, hey, if you were in DuPage County, you'd have a 50% shot, but you're not in DuPage County. You're in Cook County. You're not going to get it here. You're going to lose. Right? So there are comparative things to look at about cases, but what are other objective criteria? I find this to be a very rich area. Anybody got ideas what you can use?
The law.
The law. What does it say? What does it say? What does it mean?
But doing a mediation, you wouldn't have access to this type of stuff, would you?
No, but see, I don't need access. My question is, do they have access? Do they know what it is? Now, this is tricky, and I'll bet I know what you're thinking, or maybe a little bit, that you raise these questions and a person starts using as their quote-unquote objective criteria the verdict that they read about in the paper, where Ford Motor Company got hit with a $40 million judgment, this is your objective criteria. This can be a problem, definitely. But it's not what I'm going to say to them, here is objective criteria. I'm going to ask them to identify and define that for me. Sometimes I might say, well, tell me a little bit about the case law. What are you relying on here? Or are there other verdicts? Tell me what your research has shown. Where do you see this thing going? Or if we're in Cook County and the verdict was in, Calpoke County, I might ask them what they think the difference is going to be in front of a Cook County jury. I have a friend who is finishing law school down at the U of C, and he was assigned to work on a case. He had a summer internship with a firm, and he got assigned to work on a case in Wyoming and to research the law. And he was telling me, he said, every case is about cattle. It's about somebody's cows and somebody doing something to somebody's cows. He was really kind of losing it after a while reading all these cases about cows. So, you have to kind of ask them to try to see how that would fit in here. But so there's the law, there's cases. What else? Experts. What would an expert say about this? Usually I find when I ask that question, one attorney says, well, we'll have our experts, you'll have your experts, and they'll both just kind of X each other out. That's the way it works, right? Experts, exactly. And so there's that. What else is there?
I like to, if I have somebody that has a specific number, I like to go through with them exactly how they arrived at that number, and if there's various components, then you can reality check as each component. Well, how'd you come up with this?
Mhm.
Why do you think that
Sure.
this is the sort of thing that you might?
Because
cover?
in that large sum that they're seeking, say part of what they're relying on is compensatory damages. And you're going to say, how'd you arrive at that? What can can you prove? Or part of what they might be relying on is something that statutorily is not recoverable. For example, a lot of people think that they are going to get the judge to award them time for their time in court, money for their time in court, right? Well, guess what? I've never seen it happen. Anybody here ever seen it happen? I never have. Not going to happen. So if that's in their figure, then you need to reality check that piece of it. Now, there's other things like who's your judge? What kind of track record do they have? Right? Sometimes if I've got somebody sitting there haranguing me about how they're going to prevail at summary judgment in an employment case, I'll say, okay, how many times in the last 2 years has your judge granted a summary judgment on this? Do you know?
What if they turn it back to you? You say, no, I don't know. Can you tell me?
I'd say, I don't know. I'm asking you. Do you? You're the one going to court, not me. That's what I would say. I'd say, well, remember, I don't have to do this. You do. So what do you think the record is? If you do it in a nice, respectful way, if you say, well, here's the problem. I don't have to try this case. You do. So it's not really important whether I know it or not. I'm asking you. You know it. And again, and I might even add, again, I'm only asking you that question to make sure that you think carefully about what you're doing. Remember, this is about you. This is about your case and what you need to get. I'm not asking you that question to trip you up. I'm just asking you, do you know? Because that could be an important piece of it. Now, where I find it gets really interesting with objective criteria is to try to figure out what appeals to them. Because what they find authoritative or what they find objective is where it's all at. Because that's what's going to, in the end, be convincing to them. Some people find court cases and verdicts convincing, authoritative. Other people find other things convincing and authoritative. Yes?
Well, maybe it's not everything is there a legal issue, but it may be, well, what would your neighbor think or your mother think or your priest think or, someone whose
Exactly.
opinion they value,
Precisely.
whoever that might be.
Precisely. I was doing this Postal Service case one day where this guy alleged that his supervisor harassed him because he was gay. And at one point in the mediation, the supervisor went on about, I don't like gay people. I don't agree with that lifestyle. I think it's immoral. I think they're all going to hell, yada, yada, yada. But Mama's best friend was a gay guy. At some point, this is like 3 hours in the thing. So Mama's best friend was a gay man. I can deal with gay men. I've known gay men my whole life. My mother's best friend was a gay man. So guess who I went to for objective criteria? Mama. From there on out, it was, well, now what would Mama think of this? If Mama was sitting here, what would Mama think of the way you're talking to this guy? And would Mama approve of this? Guess what? Mama wouldn't. But that meant something. That was objective criteria to him. Now that's really tricky. You start talking about somebody's mama in any context, you better be damn careful, right? But I just he put her in there. I didn't. So I thought it was fair to say, well, I'm curious, what do you think your mother would think? If you ask your mother how you should treat this guy, what would she say? If you ask your mother, if your mother knew, and she was sitting here right now and knew what you had done, would she say it was okay? Now, he didn't answer me directly, but I have to believe that had some effect. Right? Control. You put her in there. You can use nuns. If people think that nuns are authoritative, by all means, what would nuns think about this? If we had the Mother Superior and a few other nuns here, what would they be saying about this, right? Would they say you were being a good little boy, or would they say you're being really bad? Which would they do? I did a case once that I thought was very, very interesting in that way, and I think I used this case in training, so you may have heard about it before, but I had this guy who was being charged with sexual harassment. And the complainant said, woman, that he had entered her room, they were on a business trip in Atlanta, he had entered her room, jumped in the shower with her, and they had sex. Okay? But he says, no, not true. She entered my room, jumped in the shower with me, and had sex. And I said, okay. Well, this is that moment where the mediator has to resist getting too many details. You only want details that are useful to the future resolution. You do not want details that are just there for your own enjoyment. So I didn't say anything. I didn't ask the questions that were on my mind. Proceeded to professionally work this case, right? And so at some point in there, I said to him, I had two questions for him. I said, well, first question that comes to my mind is, if you get up there in front of that federal judge and you tell me you tell him or her what you just told me, that you had sex with this person on a business trip in Atlanta, what are they going to say? What are they going to think? Answer that question. Then my second question for him is let's say that we took 6 business executives, 6 CEOs from any company along the South Street here that you want. You pick them. And we brought them in here, and we just replayed this whole thing. And you tell them everything that you told me, how this happened, what you did. And you just played it all out for them. Or let's say they could see a video of this mediation. What would they say? And he sat there for just a few minutes, and he just kind of looked up and he said, they'd say, I'm screwed. I'm screwed. Now, what was that all about? His objective criteria, the people that he really thought of as people who would be worthy of passing judgment on him, would find him in the wrong. Would say he shouldn't have done what he did. And they wouldn't buy his excuse. That was his objective criteria. So, anything that they see as reliable, authoritative, objective, that's what you use. Because that's what's persuasive to them. Right. I think that makes sense. Well, most of us really, if you think about how your own mind works, there's something in there that you would be swayed by. And other things, you wouldn't be. So there's the objective criteria piece. The flip side, the only thing I want to say about a flip side is, remember that elaborate role play we were talking about with the lawyers? That's a form kind of a third-party flip side. There are other ways of doing that. Let's say you want to flip side somebody, but they don't want to go in that other pair of shoes. They're either too tight, or they pinch, or they smell, or there's something. They don't want to go in there, right? So you put them in somebody else's shoes. You say, do you know of anybody else who's ever been in this situation? How do you think you would feel if you were them? In other words, you're not asking them to go into their adversary, be their adversary, empathize with them, but to empathize with some third-party way out there. A lot of people can do that when they can't go to the other person in the room. They just can't. They can't see themselves as any way like the other person in the room, but they could see themselves as somebody out there somewhere. So you can turn it into a third party. Let's see here. Cause for pause is one of my very favorites. Let's say you get somebody who wants $150,000 to settle the case, right? And the other side's offering, well, when you have somebody who wants $150,000 on one end, what's usually the offer on the other end? $500? Did I hear $500? Yeah, it's usually somewhere in that range. $500 to $1,000, and $150,000 on the other end. So, you take your $150,000 person, you say, well, what do you think? Where do you think they're going with this? Well, by God, they're going to get off some money, or I'm not going to do anything. I'm going to sue their pants off. I'll take them all the way to the U.S. Supreme Court. I'm going to get my $150,000, and not only that, I'm going to sue them for a whole bunch of other things, and right? On and on. Yada, yada, yada. That's when you want to say something to the effect of, well, you can sue the Bishop of Boston for bastardy, but you got to make it stick. How are you going to do that? But you can't be quite so direct with your parties, right? So what I sometimes do is I'll say, well, how about this before we close out? I'm just curious. What if they came back with, $10,000? Would that give you cause for pause? No, I'm not suggesting they take $10,000. Hell, I don't care what they take. What if they came back with $10,000? Would that give you cause for pause? No, screw them. What if they came back with $20,000? What would you think about that? Screw them. How about 30? No. Wouldn't do it. How about 50? Well, they came back at 50, I guess we'd have to think about it. Now, what did you learn there? Not quite. You're getting close. What you're learning there are the anchors, the range, the thing where they're willing to consider is really what it is. It's a way of setting their range. You still don't know because they might think all day about that 50,000 and still not do it. But it's a way of sort of identifying the range they're in. And you can move on up then. You can say, okay, well, how about 70? That would be really good. Or how about 100? Yeah, I think if they offered 100, I'm pretty sure we'd take it. Now, there's your range. Somewhere between 50 and 100 is where they would come in, probably. Yes?
Is it dangerous to do it before you've done some of the other reality testing?
Totally. That would be, that's a good point you're raising about the timing of some of these strategies. This is a, you've been in it a long while strategy kind of thing. You've been in it a long time. Now, sometimes I believe there probably is an aspect to this where they think that you are, taking it in a direction. I'm really not going to do that. I really don't have any idea where they're going to sell it. But they may think that. I can't help what they think. If they put that interpretation on it, I can't do much about it.
Would you bother clarifying that with them up front, saying, I'm just throwing out numbers here? Or would you?
Yeah, I would say this. I'm not saying you should settle for any of these figures. I'm just sort of curious about you and where you're at and what you think about it. Where would you come in? Or what would, actually, the way I usually set it up is what would give you cause for pause, just exactly that. What would make you stop and think for a minute? Because that's all it is a range setter. It's not trying to get a final number knocked down. Now, and we're talking about $150,000. It works the same $1,000 case. Doesn't matter. Same principle. Use it the same way. Reality testing principles. People sometimes say it's the principle of the matter. Right? It can be kind of tough. I think you can do a couple things with that. What I sometimes do is I'll say, oh, fine, tell me about your principles. You say that it's a principle matter. What kind of principle are you appealing to here? What's the principle this is based on?